Good afternoon, dear ladies and gentlemen, dear colleagues. My apologies that we started with a little delay. It's a long distance call from the Netherlands to Indonesia, so there were some issues on the way. We fixed them. I'm happy to welcome another prominent speaker of our series, Ichwan Sukardi. Ichwan is a managing partner of tax within RSM Indonesia, with, I'm scared to say, 25 years of experience. That's how old I am. Ichwan is very well known tax advisor, prominent speaker, very active within IFA Indonesia. I see various reports in Indonesian language, which I cannot fully appreciate, but I'm pretty much sure that it's impressive and insightful. And today we decided to discuss what are the recent international tax developments in Indonesia, because we all know these fancy Danish cases and what is happening in Europe. Everything is pretty much Europe centralized, but what is happening in other important part of the world quite often remains uncovered. And this is what Ichwan is going to help us with, to tell what are priorities, how the international initiatives are being implemented by Indonesia. So I'm looking forward to this exciting story of Indonesian international tax developments.
Okay, thank you, my dear friend Rustam, for such a nice introduction. Good evening from Indonesia, and good afternoon for those of you lives in Europe. Yeah, I was asked by Rustam to provide updates on international tax developments in Indonesia. I think we do have some interesting cases to discuss, and also some updates, and to say that there are some also interesting developments in Indonesia which may also can give additional international tax cases to be reviewed by a student and even by the professional tax consultant like us. So this afternoon I have prepared some slides already, and I think this is the root of the problem, where we delay for a while because then the slide doesn't work as it planned. So I'll update. Basically, there are 4 parts of the this evening updates, but I'll put more on the beneficial ownership issues. I think this is the more interesting part that we can discuss interactively. And if we, some of you may recall the Indo-Food case, where it's basically non-Indonesian or non-tax case. It's the dispute between the Indo-Food as the issuer of the bonds and the JP Morgan. At the time, the Indonesian Mauritius Treaty was terminated, and some provision in the the contract that Indo-Food has the right to early redeem the bonds, so they are going to use this or to exercise this right. But then the JP Morgan at the time requested Indo-Food to consider the proposal. But at the end, the case, because the contract between Indo-Food and JP Morgan was under the English law, so the case went to the British, the UK court. And as you may know, the court decided that the change of structure from Mauritius to the Netherlands structure does not meet the beneficial owner requirements under the Indonesian tax rules and also in the international tax principle. And then after that, we do have some interesting cases also, which I'll share here later on, and need also your thought on this. So okay, let's move to the. So I don't need to introduce Indonesia, but basically we are one of the. We are not OECD countries, but we are part of the G20 countries. So we are very active in the working group of OECD, including actively provide input in BEPS action. So we are a big country in terms of the area acreage and also number of population. So it is good for and we enjoy also middle income class now. So it is very good place for investment. Okay, then first I'd like to provide you probably in a few minutes on BEPS updates. So on 15 BEPS action where we are now. So basically we are one of the, I think I would say probably that Indonesia is one of the pioneers in terms of implementing the BEPS initiative. So if you can see out of the 15 action, so we almost implemented all the requirements. So I'd like to share the some actions that may also interest may also provide you a good insight. So in relation to digital economy, I think we introduced a regulation in early 2020. So this basically to say impose tax on one of the provision is to impose tax on digital economy. So we have implemented the provision on indirect tax. So we impose VAT on any transaction performed by a non-resident. So basically, if say digital economy companies, they don't have any presence in Indonesia, but then they have some transaction in Indonesia, then they don't have any capacity to impose VAT, because under the Indonesian law, the VAT is basically imposed only by the company who has been registered in the tax office. But then Indonesia lost some potential tax revenue. That is why they introduced this as a new policy. So basically, foreign companies can be registered as a VAT-able company, but they are appointed as VAT collector, basically, so that the this create same level of playing field compared to the Indonesian company. And the second one is on the direct tax, the imposition of tax on profit received by non-resident. So in this situation, I think Indonesia is quite moderate, taking the position that will wait until the global consensus has been reached. So that in this case, Indonesia is not in the position to say introduce such regulation, but the regulation is there, and the law says that any implementing regulation will be further regulated under the government regulation, but the government regulation is not issued yet. So basically, we follow the economic substance approach, and as suggested by the OECD. But then how the tax imposed is not yet, and also the how much is the tax rate is not yet determined. So I think that is the most important part. Other than that, I think it's just for the general knowledge. Now move to the beneficial owner. I think this is the one that has been the primary concerns of some investors on how Indonesian tax office aggressively interpret the beneficial owner definition. So the beneficial owner concept itself was in Indonesia was driven by the application of Indonesia Netherlands tax treaty. So it was the action of 2002. So at a time when it was introduced, the Article 11 says that the withholding tax rate on interest is set at 10%. But then if the tenor is for more than 2 years, then the tax will only be payable in the country, in the resident country, in this case in the Netherlands. So this creates a lot of uncertainties, because the tax office aggressively review the whole transaction and come up with some idea that the tax treaty, especially the Article 11 does not apply. So the interpretation of the tax treaty itself, I think it is still very relevant, because if you look at the treaty itself and also the OECD model, the concept of beneficial owner has developed over the past years, and we have to acknowledge that too little guidance in OECD commentary, and some countries come up with their domestic law, either through the issuance of new regulations, which basically it is at the domestic level, or through the court cases. And we have to acknowledge, and I still recall that some discussion with Case also, that he shared that some countries, to his knowledge, that non-member state of OECD, and he specifically point out Indonesia and China, starting using the beneficial owner requirement as a broad, treaty weapon against international tax avoidance. So that is the main point where later on we can comment whether the concept developed by Indonesia is consistent with the international tax law.
Meanwhile,
yeah.
while you're scrolling down another slide, you mentioned that Indonesia started pushing for beneficial ownership in 2002. I recall when I was studying in Leiden, we had two tax officials from Indonesian tax authorities in class. And one of them was quite senior, we graduated in 2001, so they had a couple of months to implement this as of 2002. Well, this might be coincidence, of course, but I'm just trying to get things connected.
Yeah,
it might be interesting to learn that case plays the role, and our Leiden University played a role in this process.
Yeah. I think back in your years when you were in Leiden, I think I know one of the alumni is now assuming the director position within the tax authority. So it is very high rank.
So pass on my congratulations.
Okay. Shall I continue?
Yeah, please.
Yeah, I'm not going to go into details the developments of these say the BO, I would say beneficial owner as a BO development, but basically this applies to the idea is income subject to BO requirement. I think consistent with the OECD as well. It's payment of interest, royalties, and dividend. I think Article 10, 11, and 12. And those requirements are embedded in the, we call it Form DGT, Form Director General of Taxes, which any non-resident is required to build in and then complete it and endorsed by the competent authorities. And the Indonesian Indonesian taxpayer, which is the payer of the income, is required to say submit this form to the tax authority in the period where the a payment of interest, royalties, or dividend is payable. So the as mentioned, the requirements of beneficial owner, so it was triggered by the application of Indonesian Dutch tax treaty. So the article, and then the first definition, I think there are also some other definition, but I think this is the one that I think we consider as a landmark of the this BO definition developments. The first definition is of beneficial owner is the rightful owner of income such as dividend, interest, and royalty. So the first definition is the rightful owner of income, and the income here refers as dividend, interest, and royalty. So this regulation also mentioned that a special purpose vehicle in the form of conduit, paper box company, pass-through company, and other similar form of say company would not qualify as beneficial owner. So then, other than that, it does not qualify as beneficial owner, and the withholding tax rate should be should apply at domestic tax rate, which is 20%. And then the in the 2009, so there's another also developments that Article 26, paragraph 1A stipulates beneficial owner as the person entitled to directly enjoy the benefits of such income. So this is, I think, consistent also with the definition. Now it is included and in the income tax law. So then there are some also other decree and also letters. So basically, then the regulation that basically covers the whole series of development is included in the decree number 61 and 62, and so amended by some regulation later on, issued in 2009. So basically, the requirement of the beneficial owner must made the following: the recipient of income is not tax resident of Indonesia. It satisfies the administrative requirement, and the application does not constitute as a treaty abuse. So, and there are some also requirements that the non-resident have to satisfy. Then we'll see also in the form. So I'll show you the form. But then the latest requirements is under the regulation number 10, as then later on amended by regulation 25, that some condition must be met in order to be considered as BO, beneficial owner. It does not act as agent, nominee, or conduit. So it is consistent with the OECD commentary definition. And in addition to that, has control to use, enjoy the funds, then not more than 50% of its income is used to bill obligation to other parties. And then bears risk, and last one is does not have an obligation, written or unwritten, to provide of the income from Indonesia to another party. So basically, this is consistent also with requirement number 3. So those requirements. So I think the idea is basically, as mentioned earlier, to say abuse as anti-treaty abuse. So that is why this is always I mean the regulation issued and the new policy issued is basically to respond or to react to any new cases or any new treaties or any application of structure which is considered as quote unquote does not properly structure or is considered as to avoid any Indonesian tax. So I'd like to share the first case law. So it is I'd like to say share the case based on the date of the fiscal years, or based on the old one, and then followed by the new one, and then the recent ones. So it is the case in relation to the financing structure, because I think most of beneficial owner cases review either at the tax court or the Supreme Court, they are in relation to the financing structure. So it is the case. I think we can say easily find this one, Transportasi Gas Indonesia, or TGI. The case is in relation to the application of Indonesian Mauritius tax treaty. So that for fiscal year 2003 and 2004. So at that time, the treaty with Mauritius was still in place. So the case, the tax office considered that payment of interest from say Indonesian parent company to the Mauritian subsidiary. So basically, I'll share also the structure later on. But this one is the simple structure. It does not use the double-decker structure like the one that we'll review as well. So the Indonesian entity established Mauritius company to issue bonds, and then later on bonds received by this Mauritian company will be lent to the will be provided as a loan to Indonesian parent company. This structure is why it is introduced. It's basically to reduce the financing cost. If it is issued by the Indonesian entity, and the bondholders will be subject to 20% withholding tax. Instead, through Mauritius company, the withholding tax costs on reduced to 10% because payments of interest from Indonesia to Mauritius a company at that time, the withholding tax rate is reduced to 10%. But the case brought to the tax court, and the court review whether the Mauritian company is considered as beneficial owner under the Indonesian Mauritius tax treaty. Then the court verdict at that time, basically the appeal submitted by the taxpayer was accepted by the tax court, and the company, the parent company TGI, is confirmed as a beneficial owner of the income, and the withholding tax 10% withholding tax rates should apply. And the interesting part is the verdict itself. I mean, the tax court explanation. The first point is the BO definition must refer to the international tax law. And another one, I think this is also interesting to discuss. A BO must be defined by the country of residence. In this case, by Mauritian authority, not the source country. The source country is Indonesia. The judges mentioned that the economic substance must be reviewed to determine the BO, but here there's no such or lack of explanation of the case. What is the because why it is relevant for us to review this case? Because I think this is the basis. I think one of the old landmark cases for beneficial owner, which later on means also the following cases may be inconsistent with this one. Then move to the cash flow number 2. So this is more complex structure where I think I was working with KPMG at the time. We worked together with our colleague in the Netherlands to discuss the structure, but I think it does not belong to anyone. So this is very common structure, and so basically this is to meet the requirements under both the tax treaty requirements, the Netherlands requirement, and also Indonesian domestic tax requirements. So So the overall objective is, of course, to reduce the financing costs. And the most interesting part of this structure is payment of interest from the Netherlands company if it is considered as a beneficial owner, and payment of interest from Indonesia, or the other way around, to other resident, so other contracting state, if it satisfy the requirement. So the recipient is beneficial owner and the tenure is for more than 2 years, and the interest shall only be payable in the resident country. So in this case, so the parent company it established issuer, and issuer later on also established OPCO in this case. Then later on the issuer issue bonds with the guarantee from the parent company, and then the proceed received by the issuer will be say injected as equity in the OPCO, and then later on OPCO use this equity, the injected equity, to be provided to parent company as loan. So then later on, parent company is required to say pay interest to OPCO, and this is the interesting part is that there is no withholding tax under Article 11, Paragraph 4 Indonesia Netherlands tax treaty, and this is Netherlands domestic issues that OPCO and issuer is considered as fiscal unity, so they match basically between the interest income and the interest expenses paid to the bond holders. So at the end, they.
My apologies.
Yeah.
Just for my understanding, what specifically says this paragraph 4 of Article 11? Because I recall this in the food thing, it was all about 10% withholding tax under Dutch-Indonesian double tax treaty. Is there any specific provision completely exempting interest in Indonesia?
Yeah, Article 11, paragraph 2 says that, let me check whether, so sorry, I did not quote the provision, but so basically in general, Article 11, paragraph 2 says that the interest withholding tax rate is set at 10%. But paragraph 4 says that if the income, if the recipient of income is beneficial owner and the tenor of the loan is at least for 2 years, and then the tax will only be payable in the country, in the resident country.
Oh, okay, so
yeah. And so it is end up with no withholding tax is payable in Indonesia. So as I mentioned that due to the unique tax system in the Netherlands, OPCO and issuer will be considered as fiscal unity. So they are for corporate tax purpose has to report only one as one entity. So I think that is the structure. So for Indonesian tax purpose, the if say let me check. Okay, let me give you also a background of the case. So if the Indonesian tax authority disagree with this structure and says that okay, we consider that you cannot utilize 0% withholding tax. And I'll discuss this. What is the arguments? But basically, the OPCO suppose whether the recipient OPCO in this case is considered as beneficial owner or not. But under this double decker structure or equity wall structure, if say Indonesia disputed the fact that OPCO is not beneficial owner, then who else can be considered as the beneficial owner? And we may go up under the structure, it is the issuer, or Indonesia say the tax authority, the Director General of Taxes denies that the OPCO receive interest income, then under the Indonesian rules says that not more than 50% of the income is used to say satisfies your other requirements. So OPCO in this case does not pay any interest to the issuer. Instead, they pay the dividend. So that is why this is one of the unique structure. But the Indonesian tax authority does not consider this as the whole or they does not apply the look-through structure. But the idea is for these double structures basically to say have a double arguments if it does not qualify as OPCO does not qualify as beneficial owner, and then suppose it is the issuer. And if it is the issuer, then issuer is still resident of the Netherlands for tax treaty purpose. Okay, that's the say the structure. Then the taxpayer receive a tax assessment. So the 0% withholding tax was denied, and then the tax authority issued a tax assessment that 20% withholding tax should apply plus interest. Then the case was brought to the objection, and to make it short, then it is end up at the tax court. Then the tax court, I think it is interesting, and it may not be consistent with the earlier decision of the same case, that the court case that but the end of the sorry, and now I'll discuss also the arguments, but the court decides that the issuer and the OPCO are not beneficial owner of the income. So both are issuer and OPCO, they are not the beneficial owner of the income, but both are merely a pass-through or a conduit company. But it does not say anything about who is the beneficial owner of the income. And on that basis, so the appeal was rejected. So, and the case was brought by the taxpayer to the Supreme Court, and this is the interesting part. So the Supreme Court say review this civil review application submitted by the taxpayer, and upon reviewing this case, and the Supreme Court grants the civil review application submitted by the company. So it overrules the decision made by the tax court. So the basis for the Supreme Court to come up with this decision is the OPCO. If you look at this structure, the OPCO here, OPCO is considered as beneficial owner, and the loan, the tenor of the loan is for more than 2 years. Then I think that is the key issues. But then the things that we need to note is the Supreme Court relies on the fact that the Netherlands Tax Authority issues a certificate of domiciles under the name of OPCO, and it can be verified. So on that basis, I think it is more to review the fact that the Supreme Court relies on the documents provided by the Netherlands Tax Authority. So it is inconsistent with the earlier decision. So even at the end, the Supreme Court overrules the tax court decision, but it is at the first stage, at the tax court level, it is not accepted by the tax court. So some notes on this. I think I'd like to say open any comments from the recipient, because I think I'll have one more case of the similar structure, which is very current. And this, I mean, I don't have any idea how to comment, but I think it is more on consistency and also the basis for the decision itself. But some notes on this Supreme Court verdict is the Supreme Court did not discuss why OPCO is considered as the beneficial owner. So it concluded that it is the beneficial owner. And if you look at the verdict itself, it's quite, I mean, it's only a few pages. So basically, it's it does not provide any guidance why OPCO is considered finally as beneficial owner. The Supreme Court discussed the interest income received by OPCO was not used to say satisfy the obligation to other parties. So I think this is the idea of the double-decker structure was entertained by the Supreme Court. So the use of equity injection from the issuer to OPCO instead of by loan, so it is say accepted by the Supreme Court. So I think this is quite unique and has been considered as quite say aggressive and also many comments on this, and we noted also some articles wrote based on this case. So if you want to check the case, it is available in the Supreme Court, but they are all in Bahasa under the PLN case. So it is the Indonesian state electricity company. Okay, now move to the, I think it is still similar case, but then if a PLN case was issued before 2000, sorry, it is in relation to cases before 2019, but this is the case review in relation, sorry, before 2009, but this one is after 2009, after the issuance of decree number 61 and 62. So the same case, the same structure, the same treaty, but then and even the taxpayer in this case put more substance. Sorry, if you look at this case, then the taxpayer, in order to meet the domestic, I would say to emphasize domestic tax requirements, that the recipient of income has an active business, not only receiving interest. So they put more substance, so they say inject more equity to the company, so that the OPCO in this case do also trading activities in order to say strengthen the case. And even the structure is considered as say put more say substance in the Netherlands, and but then again I think the root of the problem is not the structure itself, even how active the companies, how the company has independent management, sufficient employees, local employees, but then the fact that it is 0% withholding tax that trigger the tax office to say reject the application of 0% withholding tax. And the case was brought to the tax court, and the more interesting part is the say the I'm involved in the cases from the say objection up to the Supreme Court cases, but then I would say that this is a long way process to settle, and the case is still at the Supreme Court level, but some of them has some of the cases, because this involves the fiscal years from 2013 to 2017. So a few cases has been decided at the tax court level. So the court arguments say that the I think consistent with the earlier, that the Netherlands Tax Authority confirms that the OPCO is resident. I think this is very important for the court to confirm. Then it mentions also that the OPCO has another income which say satisfy the requirement that not more than 50% of the income is used to satisfy its obligation to other. The form DGT, the form itself is available and valid, and that because the board of judges consists 3 judges. So, but then 2 judges agree with this application, but 1 judge is provide his dissenting opinion to say argue otherwise, that the OPCO is not considered as beneficial owner of the income. Instead, it is the company itself is the beneficial owner of the income. But on the basis of majority votes and the court accepted the appeal application, and then the DGT, the Indonesian Tax Authority, disagreed with this decision and brought the case to the Supreme Court. And any idea what would be the Supreme Court decision on this?
Ichwan, I cannot hear
you.
Okay.
No, I mean, I was asking if, say, we can have a, say, vote on who is going to win at the Supreme Court level, whether this is the taxpayer or the tax authority.
Okay. Here is the voting. So please go. Who do you think won? But actually, that's interesting. When I was looking at previous case, I thought, well, it was decided in 2009, right? By that time, the Russian court might decide in a similar way, although they would say, hey guys, this is just, that's all artificial. So most likely they would agree with the opinion of tax court. They would say this is one game. It's not like upper Dutch court negotiates something with lower Dutch court and they agree. No, it's obvious it was done on purpose just to play around. But up till a certain point in time, the Russian tax court, it was taking formalistic approach, like, okay, no, that's a different entity, so that's. But nowadays, no chance, no way. They wouldn't even bother to listen to all these arguments. But anyway, so people, the majority of our listeners, they are in favor of, surprisingly, taxpayer.
Okay. Okay.
Oh,
So how many percent that is taxpayer? Wow.
yeah.
Okay. Yeah, I think the idea is, I mean, if you follow the even Indonesian domestic tax law, not to mention because then suppose the treaty restricts the application domestic tax law. But I think we are all aware that in most jurisdiction, it may not be consistent with this spirit. So at the end, only 22% wins the vote, because the Supreme Court tax, I mean the Supreme Court, sorry, this is supposed the Supreme Court. The Supreme Court accepted the civil review application. This submitted by the Director General of Taxes and cancel the tax court verdict. So it is, I mean, interesting to note this decision, that the first one is the Supreme Court decided to say open the dissenting opinion, say provided by one of the judges, and they simply follow this dissenting opinion that to determine a resident of is a beneficial owner, it must be a resident of the other state. I think that does not give any points to the case itself, because it is. Then the beneficial owner requirement are regulated under the this is purely domestic tax law, decree number 61 and 62. And the interesting part, it says that it is inconsistent with the two earlier cases, that the certificate of domicile issued by the other competent tax authority does not confirm the company is beneficial owner. To some extent, I would agree with this. It does not. It is only to prove that it is resident. Then the fact that it is a resident of the other country, then we have to look also the provision both under the domestic tax law and the tax treaty provision itself. But what surprisingly, the Supreme Court come up with the idea that the parent company, so the parent company, remember that the parent company is Indonesian company, is the beneficial owner of the income. So this is I think the interesting part of this decision. But then if you look at the treaty itself, it needs at least two countries. If you look at Article 1 of the treaties. So then if the beneficial owner is the company, so the payer is the company, the parent company, and the beneficial owner is the company, it backs to the same jurisdiction, the same country. So suppose treaty does not apply. Treaty does not apply, then it does not fulfill the requirement under Article 26. So meaning that, yeah, it fails to say applies the withholding tax provision under Article 26. Then I would say technically suppose there should be no withholding tax, but because this does not discuss in more details, I would expect that the Supreme Court gives more explanation, because the fact that the beneficial owner is the parent company itself, then simply the treaty does not apply and the application of 20% withholding tax should apply. I think that should give more explanation, but it does not say so. I think that's the three beneficial owner cases. And I'd like to show also the form itself. So I think there are two forms. The first one is issued in 2009, and then later on it was amended. So basically, if you were a non-resident, then you need to say enjoy the treaty benefit. Then you need to say fill in this form and return to the Indonesian taxpayer. Otherwise, they will apply 20% withholding tax. So if you look at the form itself, there are some tests to say part 6. So you have to say here, if one of the question is answered with say yes, and then you are not qualified to say the answer must be no. Sorry, it must be yes. And the form was amended in the following, I think 2019. So earlier it is 3 pages, and then later on it becomes 2 pages. Rustam, before I move to the next agenda, I think do we have some questions?
Yeah, we have a couple of questions. We don't really need to answer every single question simply because of lack of time. So please.
Okay.
Which you will pick up. There are some questions from Niels Rovers. This relates to the slides, but I'm just wondering, could we share the slides afterwards? So would you mind?
Sure. I'll send it.
If Niels would mind, we will just distribute the slides, and for the sake of time,
okay.
Let's move ahead.
Okay. Then now let's move to the another topic of the. So sorry, before we are discussing general the avoidance rules in Indonesia, I think the important message of this, I think the second case and the third case law, I think the Supreme Court is not consistent one to another, because the first one, the court, the tax court, say rejected the appeal application, and then later on accept the civil review application that the taxpayer on the same structure even. Then the third case, the tax court accepts the application, the appeal application submitted by the taxpayer, but the DGT applies for civil review, and the application was accepted. And this is one contradictory one to another. I think this is, and the taxpayer is considering what would be the best action to say ask for further fairness in this case. Okay, now move to the. I think I'm going to briefly discuss this because this is more on the general knowledge. So in Indonesian general anti-avoidance rule. So basically, the we don't have specific general anti-avoidance rules, but then it is included in the income tax law in the article 18 paragraph in the article 18 basically. So this consists some rules. So we'll also discuss in details in the following page. So basically, this covers substance over the form requirements, thin cap rules, related party definition, and tax treaty abuse. We have discussed the regulation in relation to tax treaty abuse. So basically, this is to limit the application of tax treaty for the non-qualifying persons. So the control, the CFC rules, Indonesia applied CFC rules since I think back 1999. Yeah, at the time we introduced a list of countries that are considered as tax havens. So any subsidiary located in those jurisdictions, if any profit, and then it is deemed to have been received by the parent company in Indonesia in certain period of time. But later on, we changed the regulations. So basically, the CFC rules applies in relation to, say, any direct or indirect subsidiary control affected by Indonesian resident, either or collectively by Indonesian resident for more than 50%. It controls directly or indirectly by one Indonesian resident or collectively, then it is called by this CFC provision. Then interest stripping loan. So basically, the Indonesian tax authority has the right to recharacterize that as equity, provided that the say equity has not been fully paid. But then most of the foreign investment company, they have to pay the equity. Basically, to some extent, the right to do this recharacterization is normally done with the extra power from the tax authority. And we do have the anti-avoidance in relation to the use of special purpose company. So this is in relation to the sale or transfer of shares of conduit company. So normally, in the past, some Indonesian entity, if they are going to divest the Indonesian company shares, they do it two steps. The first one is they transfer to affiliates at book value. The affiliate is located in the tax haven, and then later on the tax haven transfer the shares to say non-resident or other residents, which the profit itself will be say recorded in the jurisdiction with low or no tax. The last one is international hiring of labor. So this is in relation to the individual resident taxpayer receiving income in both in Indonesia or outside Indonesia. So basically, they are all subject to tax in Indonesia. And then the last part, I'm not going to discuss this in details because I think we have also differentiation on multilateral instrument. But what I'm going to cover here is basically where Indonesia is in relation to the application of multilateral instruments. So Indonesia is included as one of the countries participated in the MLI signing back in 2017, and then it requires the Indonesia to say introduce law to say ratify this, which we did in 2009, and in 2020 we deposited the instrument of ratification with the OECD. So basically, the MLI provision itself and entry into effect since January 2021, so it applies already. So we do have 70 tax treaties. I mean, Indonesia, probably now I think it's more than 70, if I'm not mistaken, 72 probably. And out of those tax treaty, 49 tax treaty were submitted as a couple tax agreement by Indonesia, and then out of 47, 39 also chosen Indonesia as their cover tax agreement, and 22 have ratified the MLI. So basically, and there are 3 countries which have not notified. So that I think 22 treaties should now the MLI provision have come into effect. So those I think put in the star mark here is the countries which the MLI provision should apply. I think I'm not going to go into this detail, but this part is important in relation to the application of MLI provision itself. Out of the 7 parts of the provision, if you look at the map here, the
Ichwan, somehow the sound is a bit distorted. So let's say something again, because at a certain point in time it was difficult to follow because of the sound.
Okay. It's probably because of the connection. Yeah, this shows. I mean, I would expect you can see the different color and different fonts color. So the yellow one is the provision that Indonesia does not adopt this provision, and the green ones with the white fonts is basically the provision that is adopted by Indonesia as part of the minimum standard, and the black fonts is basically optional part that we choose to adopt. I think that's all the update. Rustam, back to you if any question.
Well, surely there are questions. Are there any particular examples already of application of principal purpose test? Because everyone is very much curious how it's going to apply in practice, because it's not beneficial ownership, it's not a substance over form. It's there is some guidance, of course, in OECD commentary, but in some countries, tax authorities, they issue their own guidances following OECD model commentary to Article 29. So what I presume MLI is already enforced in Indonesia. So what are the expectations in respect of application of principal purpose test?
Yeah, I think that's a very good question. I think the application of principal purpose test for Indonesia is quite. It's not something new for us. I think some treaties signed by Indonesia contains already with probably we can say that mini principal purpose test already, but I do not recall which tax treaty. But the interesting part is so then so technically by this year the application of principal purpose test required under this provision should apply. So that modifies the treaty provision. But let me share with you the I think I missed to this provision. So basically the Indonesian DGT form contains with also with these requirements. So basically this is to test the parties is meet the substance in relation to the income or the income source from Indonesia. So if you look at this part, so basically this is the test that you need to satisfy. So then we need to check whether this is a more aggressive approach than the, because then if you look at the provision of the MLI itself, it does not apply to the whole provision by Indonesia. So it's only for the selected tax treaty here, only the two that have ratified the MLI and considered also as the copper tax agreement. So, but in this situation, then Indonesia applies both, the whole treaty under the domestic tax rules that requires that the substance of the recipient also must be reviewed. But the practice, whether later on the application after the MLI provision is introduced, I don't have any experience yet.
Okay, because this might be the major question mark, perhaps for the tax, and maybe even for tax authorities. How is going?
Yes, correct.
Good. Well, there have been no any further questions. If there are, please let us know. It's pretty late already in Jakarta, so I don't want to keep Ichwan to. No, it's already what 10. So
yeah,
let's give Ichwan some rest. I think we can take 1-2 questions maybe maximum. But it would be good to have from time to time, because that's really interesting how formalistic was Indonesian court in respect of this 2009 case. At the same time, it's quite predictable, that it didn't fly long, this attitude, this approach. But when we discussed beneficial ownership with Monia a couple of weeks ago, she also shared the case decided on beneficial ownership in Peru, and it also had some interesting features which are useful to learn not only in Peru but in other countries as well. Good. Well, in absence of questions, Ichwan, I would like to thank you very much for taking care of delivering this presentation. Very technical to some extent, but very useful, very interesting. So please keep us posted. And I also learned that one of my classmates became head of Indonesian tax authorities. I think I went to the wrong country after. I should also remember.
You know, when I was went back in 2004, the case mentioned if any students from Africa and then he was working for the tax authority. Then he said that, "I'll guarantee you will become at least Ministry of Finance."
So it worked. It worked. Yeah. Good. Well, these are funny jokes. Next week we are going to have a presentation of Mrs. Yimin Ku. This is a Chinese litigator.
Interesting.
Litigator.
Interesting.
And we will also do this lecture 2 hours earlier because it will be too much to ask the person to present at 11 p.m. So we decided to soften it. Okay, let's go from 9. And well, if there would be any questions from our NTDs, please feel free to shoot them. And well, we will also distribute. If you do not mind, I will post your slides after I get them.
Okay, okay, we'll send it to you
on LinkedIn. And, well, thank you very much for the great presentation, Ichwan. Yeah, thanks. Thank you.
See you again. Bye.